Okay, so we're going to kick off. Thank you so much for actually being awake at this time to be at this panel. I'm sure we'll make it fun and interesting and keep you all awake. So this is, it's a really, really important panel, at least we think so because we're working on this project, looking at criminalization of speech on the internet. And it's a project that we're doing across 6 countries, and it's led by APC. Digital Asia Hub is one of the partners involved, and I'm really happy to welcome all of the other partners who are working with us. So we have Geeta Hariharan, who's actually going to spell out the international framework, which is the backdrop to this project, and she'll say a few words about the methodology that's being used. We have Nayanthara, who's going to talk about the Indian piece of the project. We have Pat, who'll talk about Cambodia. And we have Dobby, who'll talk about the Malaysian project. We have Sadaf, who'll join us remotely from Pakistan. And then we've got Ed from SIPA, who'll talk about the impact of all of this criminalization of speech on the media as the head of the Southeast Asian Press Alliance. So really interesting set of speakers, and I'm just going to hand over to Geeta to set the frame for why this project, why this particular topic, and how we expect to approach this and what the methodology is, as well as the international frame against which the in-country studies are being done. Geeta, go ahead.
Hi. So I have 2 things to do today. The first is to talk about the methodology that we're following in this project. And the second is to talk about the international standards. I'm going to give a brief overview of the international standards for freedom of speech and expression, so that we have a certain fundamental understanding of how to approach this issue in national contexts. About the methodology, there are 2 aspects that we've taken on. The first is a theoretical understanding of freedom of expression, and the second is to look at what exceptions countries have provided in restricting and criminalizing freedom of expression in online in these 6 countries. So about the legal foundations, what we're looking at is a set of foundational laws, that is constitutions, laws that apply specifically to the cyberspace, to see what each state has set in place for an understanding of freedom of expression. So in India, for instance, there's Article 19(1)(a) of the Constitution, which guarantees the right of freedom of speech and expression. And this right can be curtailed only according to the requirements that are given in Article 19(2) of the Constitution, which spell out certain justifications on the basis of which the government can curtail these rights. So each country has a set of these principles, except for Cambodia, which applies international covenants directly into their law, and Pat will talk more about that in detail. The second, about the classifications that we are following. Most countries provide a certain set of justifications for curtailing international freedom of expression and speech, even though these are not specifically applicable to the online space, because most of these laws, many of these laws were written into practice prior to the online space exploding as it has. Some of the justifications that these 6 countries provide, and many other states across the world, situations like national security, public order, protecting the rights of others, violating friendly relations between states, sedition, blasphemy, hurting religious sentiments of a group, and obscenity, pornography, and related sexual expressions, contempt of court, defamation, and situations such as these. Obviously, there's questioning about whether these conditions are apt and to criminalize freedom of speech and expression, and that's one of the issues that we'll deal with in the project itself. Now, why are these justifications important? These justifications are important because in the international scenario, if we look at the International Covenant for Civil and Political Rights, which is the main covenant that we're looking at, there are certain restrictions that are available to states to curtail freedom of expression by. So what I want to do is to first talk about the content of the right under Article 19, of this Covenant for Civil and Political Rights, then go into the restrictions of the legitimate restrictions that governments can make, and then look at one of the exceptions, one of the special situations, that is hate speech and provocative speech. About the content of the covenant. Article 19 says, everybody shall have the right to hold opinions without interference, and everyone shall have the right to freedom of speech and expression, and this right shall include the freedom to speak, seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing or print, or in the form of art, or through any other media of his choice. Now, an authoritative interpretation of Article 19 has been given by the Human Rights Committee, and this is called the General Comment 34. I want to make a slight digression here to talk about the Human Rights Committee. The Human Rights Committee is a group of 16 experts who come together 3 times a year and provide authoritative interpretations of different articles of the covenant, and they also receive individual communications from different states and to decide upon those individual communications, those states that have signed the optional protocol to the Covenant for Civil and Political Rights. On the other hand, the Human Rights Council is an intergovernmental body comprising 47 states, which meet once a year and pass resolutions on, relevant resolutions on provisions of the International Covenant. So what is the content of this right? So General Comment 34 says that the 2 freedoms, that is the freedom of opinion and the freedom of expression, are closely related. The freedom of expression provides the vehicle for exchange and development of opinions, and therefore freedom of opinion under the covenant has no exceptions whatsoever. Everyone, all opinions are protected, including opinions of a political, scientific, historic, moral, or religious nature. There are no exceptions to this. Secondly, the right of free speech and expression is available regardless of frontiers, and these include all forms of audiovisual as well as electronic and internet-based modes of expression. Now, when the General Comment was written prior to number 34, which was General Comment 10, it didn't address electronic and internet-based modes of expression. However, the current authoritative interpretation, which is General Comment number 34, states clearly that freedom of expression is available across electronic and internet-based modes of expression, and this is available not only to individuals but also to media outlets. That they must take account of the extent to which developments in information and communication technologies, such as the internet and mobile-based electronic information and dissemination systems, have substantially changed communication practices across the world. Now, specifically, the Frank LaRue report of 2012 explains clearly that access to the internet means 2 things. One is access to online content, and the second is access to infrastructure, availability of infrastructure that makes access to the internet possible in itself. And these rights that we have under Article 19, the right to freedom of speech and expression, clearly apply online. That is, the existing international human standards, in particular, the restrictions of Article 19, paragraph 3 of the International Covenant, are pertinent to determine what kinds of restrictions can be placed online. That is, the rights and the restrictions under Article 19 apply not just in offline situations, but also in online situations. Now, what are these restrictions? The restrictions are that the rights can be curtailed under 2 circumstances. The first is for the respects of rights and reputations of others, and the second for the protection of national security or of public order, or for public health and morals. Now, while these are the justifications under which restrictions can be provided, there are also 3 other tests that each restriction must follow in order to be considered legitimate and valid. The first is that of legality. That is, each restriction has to be established by law, and the law being either a legislation that's been passed, or an order of the government, or a judicial pronunciation, and that these restrictions can only be for reasons that have been set out in Article 19.3. That is the ones that we just read. And the third is that of necessity and proportionality. For this, for necessity, the question would be, is there a pressing social need in the country that requires a curtailment of Article 19, and for the question of proportionality, is there another lesser restrictive method on the basis of which these restrictions can be placed? So I want to take an example of an internet ban in India, which came on the wake of an agitation in a particular state. Now there the question would be, is the agitation severe enough to produce a situation of emergency in that particular state? If that were the case, then perhaps the state would have a justification in stating that it is necessary to set forth an internet ban. Now the second question, which has to come in addition to the first question, is that is there another lesser restrictive method other than an internet ban, a complete ban on communication services, which allows the government to reach the same requirement, which is to contain the emergency situation? If there is a lesser restrictive method available, then if the government introduces an internet ban, then that would be in violation of Article 19 and Article 19.3 of the International Covenant. And while national contexts are different, it is important for us to understand this within the international context, because many of these countries, most of these countries, 196 countries are signatories to the International Covenant, and therefore it is customary international law and therefore applicable to every state in the world today. Now, the last thing I want to talk about is an exception, is a special situation to Article 19, which is Article 20, Clause 2 of the International Covenant, which says that any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. It is easier to call this hate speech or provocative speech, and it's important to understand two separate prongs of this of hate speech and provocative speech. The first is that content that offends, shocks, or disturbs certain people are not by their nature, are not per se against Article 22, and therefore the government cannot, just because they offend people, restrict these expressions. So then what is required for the government to legitimately restrict this expression? What's needed is that there is an imminent threat of violence if a particular statement is made. So for instance, if there is a direct and public incitement to genocide, direct meaning there must be communication which it's sufficiently specific for a particular action to take place, and that the speaker has an intent to incite for the act of genocide or of violence, and that this intent is carried out, and that there is a likelihood that this intent will be carried out in practice. If these conditions are met, then provocative speech becomes legitimately restrictive, can be restricted under Article 20, Clause 2 of the International Covenant. In other cases, when it simply offends, such as obscenity or pornographic content, then purely for this reason, the government cannot restrict such expression. So the three requirements under Article 20, Clause 2 to look at whether the action can be legitimately restricted is the conduct of the speaker, his intent to see whether he intends to incite the violence and whether there's a likelihood of the violence to actually happening. And finally, the imminent danger of the public being incited to do a particular act, whichever act that the person is saying that that should happen. So this is the international, these are the international standards on the basis of which speech and expression can be legitimately restricted in the national context itself. Now I'm going to hand it over to Nayantara to talk about the Indian situation. Nayantara.
Thanks, Gita. I'm going to talk about 4 main trends that we've seen so far in the initial stages of our research. The first one is a prominence of provisions that are securing the status quo. Now, what I mean by that is a prominent provisions which are securing the interest of the state or interest of collective morality, whether real or imagined. These provisions having a higher place in implementation than user-centric or individual-centric rights. Now, to give you an example, Section 43 of the IT Act is about tampering with, stealing, or deleting information from computer systems. Now, there have been data breaches, big and small, ATM networks that have been breaches in the ATM networks, smaller breaches, but this section is often like gathering cobwebs in the statute, right? As opposed to something like section 124A of the IPC, like sedition, where Snapchat filters or somebody even receiving a message which is considered offensive or which is considered to be derogatory to persons in the government is used. I mean, the provision for sedition is used in a lot of really frivolous cases. Another example for this is in the IT Act when it comes to the preference of section 67, which is on obscenity. So using of the obscenity section, which is more about a collective morality, as opposed to section 66E, which is about section 66E is punishment for capturing, publishing, transmitting images of private areas without your consent. So that is more of an individual-centric right. It centers consent, but that's not used as much. And yeah, that's another example where this plays out. I guess an exception for this trend would be criminal defamation. A lot of cases of criminal defamation get filed even now, and that is for criminal defamation is for the protection of an individual's reputation. But even then, often the persons filing for these charges either have the blessing of corporate interests or have the state behind them in some form. So even there is they're on the right side of the power imbalance, the persons filing these charges. Now the second trend that I want to point at is about implementation and policing of is in relation to implementation and policing. So from a policing point of view, the mechanism of self-censorship is found to be most useful in conversations with the police. So they almost have a sense of nostalgia for section 66A, which got struck down in section 66A of the IT Act, which got struck down by the Supreme Court in 2015 as unconstitutional. So it had really broad buckets of categories which it deemed offensive, which it deemed criminal. So it was like offensive, grossly offensive, menacing character, causing annoyance, inconvenience, none of which is defined. So these categories were quite easy when for the police to book cases for, which they find no longer exists. And yeah, and as a senior police officer, quite candidly admitted about the state of police stations and the state of reporting, is that a lack of capacity in the police actually makes them discourage filing of charges under a lot of different sections. So whether or not it is intended, when cases are filed for sedition for receiving a message or being a WhatsApp admin, where WhatsApp admin of a WhatsApp group where such a message has been received, it creates a kind of chilling effect on in general. So to give you an example, recently in Chennai, there was a case where a person who was actually apprehended for abetment of smuggling was actually, the police went through his messages and found a voice message that called for a protest about disrespecting the Quran, which had nothing to do with sedition, but he was booked on charges of sedition, and eventually the magistrate let him off. But the letting him off doesn't make news as much as him being arrested for such a thing. And while chilling effect is a challenging thing to measure from a research point of view, it does create, it does create such an atmosphere. And I think in this context, it's also important to mention the Aadhaar project and its potential for surveillance. So when your mobile phones are mandatorily linked, when your web search histories are part of that, and even if you want to call an ambulance, it's going to be linked to your number. So in such a situation, the potential for surveillance could be huge. And while we have no data at the moment, I think it's just important to keep that in mind. Another blunt instrument, as Geeta already pointed out, is section 144 of the Criminal Procedure Code, which is used for network shutdowns. So it actually is for curbing unlawful assemblies or preventing apprehended danger. This is another favorite instrument that is often used, a blunt instrument that is often used. Now I'll move on to the third trend, which is the rough consensus around the fact that child pornography is bad, this being borrowed or exported to criminalizing sexual expression in general, is another big trend. So in a petition before the Supreme Court, for example, there was, the ask was for blocking pornographic sites, especially child porn. Now what does that mean? Do you want to block pornographic sites? Is that a different hierarchy? So there's often this conflation, and this is also evident in some lawmaking as well, because for example, the Indecent Representation of Women's Act, which was a legislation in 1986, it got amended in 2008, which became Prohibition of Indecent Representation of Women and Children Act, right? So suddenly you have the conflation of women and children categories, which requires different approaches and probably like do not even merit being put together. Yeah, so just to quote the judge from that case, in the directions to the government to ask for banning of child porn sites, the judge says when law prohibits obscenity and porn is directly obscene, then you have to ban it. How you ban it is a different issue. Yeah, so that's the third trend that we saw. And the last one is with regard to draft laws. So in a lot of draft laws that have been being put out by the government, the lack of a user-centric lens is quite prominent. And I want to take two examples. One is of something called the Geospatial Information Regulation Bill. It was a bill which made geospatial information, the publishing, the transmitting, the storage of geospatial information criminal. Now, what is geospatial information? According to the definition, it could be your Uber map or any kind of logistics company map that you might use to order food in, to find directions, or even me putting a dot from my hotel to this place and like drawing out a representation of geospatial information on paper. So all of this was criminalized, and if you needed to publish such information or even have it with you, you need to go to a security vetting authority for this. And so if I have a map and I kind of point a new dot and write it, it would count as value addition, and you have to go back to the security vetting authority. And in a lot of cases where like there's moving traffic and you have all of that represented on your maps, it doesn't make sense, right? So a lot of people like students, persons that use volunteers of open source projects like OpenStreetMaps, so many different people are affected from it, and whether or not we agree with the intention of the bill, the design of it, it's exemplary in not keeping users in mind. And this is also the case with the draft encryption policy, which also got revoked. So even there, it required the users and businesses to store any encrypted communication in plain text for up to 90 days. So whether or not we like the intention, it's really hard to do. So like a very one-sided thinking from is evident in a lot of draft laws.
Mahitala, thank you so much. The thing about conflating women and children reminded me of one of the most awful signs that I've ever seen at the Bangalore Club, where they have a men's bar in this day and age, but they had a sign from colonial times which said, no women, children or dogs. And the staff were actually happier to allow dogs in than women or children. So it's not surprising at all that the same sort of mentality carries into the way that we approach legislation. This is in India, yeah. They've taken it down now, but I think like last year. Yeah, but they still didn't allow women to be members of the club until very recently. Second-class citizens, no, Bangalore. Yeah. But it's all for our own good, obviously. So I'm now going to turn to Pat from the Cambodian Center for Human Rights. He's a legal consultant with them, and he's going to talk a little bit about what, sorry? Do we have Sadaf first? Okay, sorry. We're going to go actually remotely to Sadaf, who's in Pakistan, from Media Matters for Democracy, who's going to talk to us about their work on the project. Sadaf, can you hear us? guess we are getting pat after all, which is a shame. It would have been really great to have Pakistan as a contrast to India, because every time I think India is doing absolutely terrible things, I have to look next door and say, okay, maybe we're not the only ones. So, Pat, tell us how terrible things are in Cambodia, or not.
Wonderful with that segue. You're prepared. So yeah, thank you. Thank you for inviting me. So I think for Cambodia, the legal and political context is, as far to my knowledge, very unique. So I want to just.
Hi, can you guys hear me?
Oh.
Lag of about 7 minutes. Hi, how are you, Sadaf? Can we have you on now?
Hi, I'm good. Sorry for the technical thingy.
No problem. We can hear you. Go ahead. We've just had India so far, and you can.
Okay. It's really nice to be able to join this remotely, and I was just listening to the presentation from India, and once again drawing parallels on how India and Pakistan are so similar and how they voices that deal with political dissent. For Pakistan, from the research that we're doing, I will start with defining the 3 different ways in which speech is being criminalized. First, it's being criminalized through different sections of the Pakistan Penal Code, like Section 124A that deals with sedition, and Section 295A and C that deal with blasphemy. Then there are counter-terrorism and related laws that have been extensively used. They're not laws that primarily deal with speech, but they always contain a clause or a section that deal with the necessity of cracking down on speech that either promotes violence or hate speech or glamorizes terrorism or some kind, glamorizes and glorifies terrorism of some kind. And then finally there are industry-related laws like the Cybercrime Bill and the PPA Act and the Telegraph Act, which technically are designed to deal with regulation, licensing of the industry, but some clauses have been either sneakily or deliberately put in to ensure that the authorities, the regulatory authorities, have some control over the content that is being shared online. The law that has been most often used online, and that on which we can actually see some case law being developed, is the blasphemy law that's applied to Section 295A and C of the Pakistan Penal Code. Section 295A deals with deliberate and malicious acts to outrage religious feelings. It's been one of the most used and abused laws, and the problem with using this law is that it obviously there are a number of cases that are going on against people who have been charged on conducting blasphemy online through different social media platforms. We have had a recent conviction in which the convict was given the capital punishment, not the punishment, they've been given the death sentence. The case is in appeal right now. But in addition to the investigations and convictions under the judicial system, every time there are accusations of blasphemy, especially in the online spaces, we have seen mob violence, a form of vigilante justice, obviously misinformed, and that has been done with impunity. There has been no crackdown against people who have actively reached out to perpetuate violence against people accused of blasphemy online. In addition, there has been a demonstrated lack of political will to even move towards a system where people who just kill and torture on a mere accusations are convicted. We had a very unfortunate case in April this year, April 2017, when a young student, Mashal Khan, was brutally murdered by his fellow students in Mardan University. The murder was not just brutal, the mob was highly agitated. They even tried to mutilate his remains. He was accused of blasphemy, and later it turned out that not only the blasphemy accusations were false, but they were actually instigated due to his position of some um, some corruption that university administration was involved in. And later what happened was there were all these posts being circulated allegedly from Mishal Khan's account, but it was never proven. It was never actually properly investigated who was behind spreading of this false information. Another act that has been used, another section that has been used often is the Section 11W of the Anti-Terrorism Act. The section basically criminalizes speech through basically any medium which can incite religious, sectarian, or ethnic hatred. While given Pakistan's context, it's really important to have mechanisms in place where incitement to direct sectarian violence, through which incitement to direct sectarian violence and religiously motivated violence can be tackled. What has happened in application is that the section has not really stood up to the test of necessity and proportionality. We still see a difference in the way the majority and minority sex speech is being tackled. So you see a lot of banned, proscribed terrorist organizations openly running Twitter and Facebook pages, issuing fatwas that directly call for the killing of the Shia minority sect, and doing so with impunity, while the majority of cases that have been instigated for online speech that's in any way linked to religious speech have been against Shia posters. So we see, moving on to the third way through which laws are speech is being criminalized. I'll discuss specifically the latest bill that was passed, the cybercrime bill. It's the latest industry-related bill. When PICA, the Prevention of Electronic Crime Act, PICA, when it was being debated in the Parliament, a lot of organizations, including Media Matters, international organizations like APC, raised serious concerns. The UNSR on FOEs issued a statement to the government expressing his concerns about the act's impact on speech online. And what we have seen in the almost 1 year, not 1 year, 9 months of this act being implemented, is a complete misuse of the law. The Pakistan has been in the middle of a controversy that originated from Twitter when the ISPR Inter-Services Public Relations Department refuted a government statement through a tweet, which led to various political party leaders, including cabinet members, giving public statements against Twitter itself and basically designating Twitter as one of the key causes of political instability in Pakistan, which led to the Interior Ministry announcing a sustained crackdown on social media, particularly against people who talk or criticize the army. Following that statement, we have seen a lot of activists, bloggers, journalists, not formally arrested but brought in for investigations and interrogation by the FIA. There have been reports that they were voluntarily asked to submit their devices for search, and the FIA just got them to sign a form saying that they were doing so voluntarily, which obviously goes against the law, which requires them to have a warrant to even touch anybody's devices. A section that has been used, the section that has been used to bring charges against some of these bloggers is Section 21 of the PICA. And it's very strange because the section actually deals with the dignity and modesty of natural persons. So far, we have had no clear indication of how the section actually applies to speech against army or army personnel. But that's how the FIA has been operating so far. one of the sections that were of key concern was section 37 that deals with blocking of online content. And the issue with that section was that it borrows language directly from the Article 19 of the Constitution, giving PTT and executive authority the power to interpret constitutional provisions, which technically should be the mandate of the Supreme Court. The government was supposed to submit a 6-month report, say, in the Parliament, defining how exactly that session was used. That report is due yet, and opposition senators have actually submitted request asking the government to follow up on its promise of more transparency of how the section particularly has been implemented. In addition, the last trend that has been really dangerous is the basically the disappearances. And we have had 5 bloggers who had gone missing in the beginning of the year. They were later recovered. One of them eventually went to the UN and accused the state of picking him up and putting him under torture. There also have been arrests of political party workers without any formal charges being brought out against them. The agency that is involved in that sense is the FIA, the Federal Investigation Agency. So we are assuming that they're doing so somehow by abusing the electronic crime bill. All this has led to a lot of self-censorship online, particularly when it comes to political speech. So yeah, these are the major trends we are seeing in Pakistan these days with regards to criminalization of speech online.
Thank you so much, Sadaf. I think that it's so clear that there are so many parallels across, the work that we're doing. This sort of the propensity for mob violence, people taking justice into their own hands, being left with impunity, not acting is as bad as the government doing something terrible. The chilling effects that are happening, the lack of data, the impossibility of even, sort of untangling some of this from the political angles, and the use of international institutions to bolster what's going on internally. And I think it's a really clear case of how the heckler's veto is so alive and well in this region, where you create exceptions that allow the government to intervene and to suppress freedom of speech, and then you create conditions very cynically and intentionally to create a state of emergency such that you're justified in going in and curbing speech. So I think these are really disturbing trends that we're seeing across the region. So I'm also really happy we have Ed to talk about the impact on journalists, because they're the sort of first line of defense here, but they're also the ones most exposed and vulnerable when they try to call truth to power in these situations. So really looking forward to hearing Ed tell us about the media angle in this. Thank you, Sadaf. Are you going to stay online so we can ask you questions, or would you prefer that we take a few questions now?
Yes, I'm here.
You're here online. Okay, great. Thanks. So we'll just turn to Pat now to continue about Cambodia.
Great, thank you. Yeah, as I was about to say before, so it's important to frame recent developments and trends around criminalization of expression online in Cambodia in its peculiar kind of constitutional, legal, and social context. So up until just a couple of years ago, traditional media, all media outlets were very heavily controlled by members of the ruling party and their friends and cronies, so television, radio, and newspapers. And internet penetration and subscriptions in Cambodia were exceptionally low just a few years ago. So in 2008, there were only 40,000 subscriptions, and in 2016, it's up to 50%, so 7.25 million. And that has had a really revolutionary effect in terms of democratizing a very young and somewhat agitated population around demanding reform for democracy. So in 2013, there was an election in Cambodia, and elections which have been typically characterized as not being free and fair as happening, but being preordained as returning the ruling CPP to power. And this one was a bit of a shock in that they allowed the opposition leader, Sam Rainsy, to return from exile on the eve of the election, expecting again a victory with just enough legitimacy to continue to receive donor funds, etc. But it was a shock for everybody, especially for the ruling party, that the opposition almost won that election. They came within a hair, within a few seats. And one of the main factors behind that was this digital revolution which had taken hold in Cambodia, under the noses of a complacent ruling elite. And the organization around that result had happened a lot online. So not only online, but a huge amount of it. So youth, workers, trade unionists, human rights activists, and other opposition forces had kind of united, organized their assemblies, meetings, protests online, and that led in large part to this surprise result. So the context since 2013, 2014 has been shaped by that event. And we've seen a string of legislative moves, prosecutions, and other actions by the government aiming to restrict freedom of expression, and especially online, to ensure that at the next election, which is happening next year, they're not leaving so much to chance. So that's the very recent context, the beginning of this crackdown. And again, before going into the details of those legal changes, prosecutions, etc., I would just mention, as Geeta briefly alluded to in her introduction, that the Cambodian legal system, because of its history, is very unique. So in the early 1990s, at the end of a long, drawn-out period of civil war and conflict in Cambodia, the United Nations kind of ran the Cambodian government, the United Nations Transitional Authority for Cambodia, for over a year, and they conducted elections. But at that time, a new constitution was introduced, and with heavy UN and international community participation, it led to international legal norms and human rights standards being directly incorporated into the Cambodian constitution. So Article 31 of the constitution in Cambodia states that Cambodia shall respect international treaties related to human rights, and including the Universal Declaration of Human Rights. So it's really quite something to have the Universal Declaration of Human Rights directly applicable, because that's even more expansive than the treaties themselves. So that itself is quite a starting point. Then in 2007, fast forward a bit, the Constitutional Council of Cambodia, the body charged with interpreting the constitution, found that this should mean the direct applicability, so that it doesn't need to be litigated to be applicable. So the government should be applying these norms in their lawmaking and law enforcement. However, Cambodia is also very much characterized by the absence of rule of law, an exceptionally partial judiciary. Generally, it comes bottom in the rankings in Asia for rule of law, and in the bottom 5 or 10 globally annually. So, as well as the lack of independence, it's a weak and nascent judicial and legal system. Development of legal norms is quite lacking. So, I mean, from an advocate's perspective, it's good because we can rely upon these legal norms outlined in the general comments in the international treaties as our starting point and entry point for advocacy. Unfortunately, the court system, despite this constitutional provision and this decision of the Constitutional Council, rarely applies or never applies those standards. So that's the context. And recently, as I said, there's been a concerted effort legislatively and also from a policing perspective to curb freedom of expression online. In 2016, we saw the passage of a telecommunications law, and that was the first kind of sectoral specific law looking at the internet space. And that was, as I think was mentioned in respect of India, characterized, like a lot of laws in Cambodia, especially controversial laws, characterized by exceptionally broad provisions which will give enormous powers for subjective interpretation to the Cambodian government. So, for example, the telecommunications law, it bans unauthorized surveillance of communications, including internet, including telephones, and all forms, unless there is approval from a legitimate authority, and it's not defined. So basically it gives carte blanche, full power to the Cambodian government to surveil without any judicial oversight, because the legitimate authority could be a minister. So that was potentially already in practice, but then it became law. So an exceptionally broad provision and no protections for privacy in there. I mean, lip service, yes, but that's it. It also, it didn't nationalize the telecommunications sector, but it gave an enormous amount of at least political access and control to telecommunications providers for the Cambodian government. So it mandates that all of the private telco operators, internet service providers in Cambodia must share all their data, basically, with the Ministry of Posts and Telecommunications. And it created a body, the regulatory body, which has enormous powers to access all communications. So legally, there's very little protection and huge access to data for the government. But yeah, we're still not sure the level of technological capability of the government. There's been hardware brought in from very advanced technology brought in from China, Israel, and other states, but the level of technical capability within the ministry is uncertain as yet. But as I'll get to, there has been a lot of leaks and hacks targeting oppositional figures, so we can imagine that there is some technical capacity there already. Aside from the telecommunications law, one of the main trends, which I think is really worth highlighting in Cambodia, in this period, say the post-2013, the period post the last election, is that rather than directly criminalizing or introducing amendments to the criminal law to target expression online, we've seen a huge assault on freedom of association. And within these pieces of legislation targeting freedom of association, provisions which go to expression. And they're obviously completely interlinked anyway. So the main forces, organizing forces behind the opposition surge and the protests which followed that election were the trade union movement, civil society, kind of human rights activists, and then obviously the political opposition. So three main forces. And since then, we've seen three major pieces of legislation passed which target those three groups. So firstly, a law on associations and NGOs, highly restrictive and way out of step with international standards. We've seen a trade union law, very similar provisions. We've also seen law on political parties amended very recently. And so these three sectoral laws targeting the main organizing forces of dissent and organizing, say, dissenting expression have been targeted. So for example, in the law on NGOs and associations, the LANGO, it states that associations must maintain political neutrality at all times. But again, this is not defined. So, and we've seen the government then threatening to apply that Article 24 against NGOs for simply stating that someone X is a political prisoner. So that is seen as politically partial. And obviously this applies online as well. Similarly, in the law, the very current, it might become law today, another amendment to the law on political parties states that if any convicted person, if they express support for a political party, that political party may face dissolution by the ruling party unless they actively denounce that expression of support. So the tacit acceptance of the support of anyone convicted of a misdemeanor or felony anywhere in the country could lead to the dissolution of a political party and, you know, almost the elimination of democracy. The trade union law has sanctions which, you know, similarly for various types of expression can lead to the dissolution of the trade union law. And each of these laws have these exceptionally broad provisions. And we can see that they're technically administrative sanctions, but exceptionally powerful and broad administrative sanctions. And they often can be coupled with criminal actions against individuals. So just a couple of examples to finish. So we've seen another trend in general, not just online, but especially pronounced online, is that there's been little indication of political will on the part of the Cambodian government and authorities to enforce these provisions which criminalize expression en masse or systematically to target everyone who's posting online. Rather, the favored tactic is to go after high-profile individuals and hope for the chilling effect, and that's proven quite effective. So maybe some of you, if you have any familiarity with Cambodia. Okay, sorry, I'll wrap up. Kem Lay was a much loved political analyst and commentator, one of the most beloved public figures in the country. He was assassinated on the 10th of July last year in broad daylight in Phnom Penh. And most observers would conclude that it's a likely hit, a government-sponsored hit. But since then, there have been, and this is illustrative, I think, of the dynamics at play. There's been at least 4 high-profile prosecutions of individuals who have said that, who have linked the government to that murder. And so two of them are involving politicians, the leader of the opposition and an opposition senator. Both have had to go into self-imposed exile because of the criminal charges of incitement and defamation which were brought against them. Another political analyst who commented on it on radio was also imprisoned. He's still in pretrial detention, Kim Sok. Yeah, so sorry, that's 3 main ones. And then the other case I wanted to mention was another opposition senator who posted on Facebook a doctored border treaty with Vietnam. It's a very sensitive issue, the border demarcation between the 2 countries. So he posted a fake one. You know, it was a silly post. Posted on the Facebook page of the leader of the opposition party. Both were, so the one who posted it was convicted of incitement and forgery. The leader of the opposition, whose Facebook page it was posted on, was convicted as an accomplice to that crime. And then the 2 staffers of the political party who happened to be admins of the Facebook page were also both convicted. So 3 of them are now in exile and 1 of them is in prison. So the chilling effect does come from that. And just to highlight, you know, CCHR and among partners, we did research this year, and it found that 82% of civil society and trade union leaders report self-censorship now. That's our baseline, so we can't compare it to before, but that's how it is. So sorry if I have gone on for too long, but that's Cambodia, and yeah, thank you.
Super depressing. Oh my God. It's almost like this medieval thing of, you know, when you had heads on stakes outside castles and outside the entrance to a city as a deterrent. It's kind of this sort of online equivalent of, you know, putting these posts saying this is what's going to happen to you if you go along this path. Really scary. We'll move to Malaysia. Do you have more cheerful news for us? Malaysia?
Well, not necessarily for the country, but for the people here, yes. I'm, for once, very thankful with my government because we have a very simplified system for me to explain. We have 1 article in our federal constitution that deals with freedom of expression, assembly, and association. It's like 3 lines, and there's about 10 exceptions to it. So there's no international convention that applies to civil and political rights in Malaysia. We only sign on to the CEDAW, the Child's Rights Convention, and the rights of the persons with disabilities. And none of them they are ratified, but they have no any application in Malaysia. It's not applied anywhere. Judiciary would say, no, we do not follow international conventions, even in principle. No. So even when there's a case that goes up to it, and they say, hey, we have ratified the law, we have a local domestic law, and this is how the UN has interpreted it, the judge would say, no, not in Malaysia. So that makes things very easy. And then when it comes to internet, things are even more so easy, because our judges would just say, internet, offline, online, no difference, the law applies equally. And that applies for civil in terms of contracts. It also applies in terms of criminal law. So here's a little bit of a slightly more depressing or entertaining part, I guess. Freedom of expression in Malaysia was traditionally curtailed, not through laws like the Sedition Act, even though it has been around since 1948. It was not curtailed to defamation like Singapore, but it's curtailed to security laws. So in the 70s, you have, let me sidetrack a bit. In Malaysia, we have this law called the Internal Security Act that has been repealed in 2012. This law allows the Home Minister in Malaysia a power to detain someone without trial for 60 days, and subsequently extend the detention for 2 years, and they can renew the detention order indefinitely. So we have had people that was detained in such a manner for about 16 years, I think, for false allegation of being a member of the Communist Party. So in the 70s, this was used to detain Labour Party activist, Labour Party politician, which effectively destroyed the party. In the 80s, it was used by our current opposition de facto leader, Mahathir Mohamad, a dictator of 22 years that now became our savior. I guess that's a good news. So he detained, I think, about 150 to 160 activists and opposition leaders under this security law. And in 2008, they used it to detain a pretty well-known opposition blogger turned government blogger, Rajat Petra Kamarudin, and a member of parliament and a journalist. So we have no qualms with using our security laws against civil society and opposition members of parliament and whatnot. So one thing has changed though in Malaysia. When the internet came to us in the 90s, late 90s, it drove the Reformasi movement, our protest led by Anwar Ibrahim back then. It started our first independent online media, which challenged the monopoly on news, which has been strictly controlled by the government, either through direct ownership or censorship. So suddenly the playing field has changed, and the government was not fast to react to it. And it was only until 2008 where they realized their power and control over people and the control over freedom of expression has been shaken to the point that people are not afraid anymore, in a sense. Because when I was growing up in the 90s, my parents would literally look at news on politics on TV, and halfway through they'll whisper, "We shouldn't be talking about this. We might get detained." And you'll be like, "Who are you to be detained?" But it's the kind of sentiment of fear that's there. And it's not just in my family, but it's the thing where you go out to other families, you talk to them, and there's always a hushed silence when it comes to politics. So there's those kind of fear there. And we're not even touching on the racial elements in Malaysia yet. But I'll leave that out for today. So with the internet wave bringing about a democratic transition in that sense, or more discussion, more power to the opposition, more room for discourse, the government in 2008 used the security law like they used to against the blogger, a member of parliament and journalists. It backfired really badly on them. So when it comes to 2012, when our Prime Minister, our current Prime Minister, ascended to his throne, his Prime Ministerhood, sorry, he sometimes acts like a king sometimes, so when they used the Internal Security Act, it backfired on them. So in 2012, they actually repealed the Internal Security Act. But it was not repealed because they decided to comply with human rights standard. They repealed because they found that it was counterproductive. And this was actually let slip in one of his speeches when he mentioned using the law against opposition leader makes them stronger. It's not efficient for us. So that's why we're repealing it. And it conforms to the trend we see. In 2012, the law was repealed, and the Use of Sedition Act went from about maybe a dozen cases up to 200 cases within a year. And then after 2 years of strong campaigning, lobbying through the UPR process and whatnot, the Use of Sedition Act fell from 200 to about 12 or 18 last year, I think. But our new other law, the Communication Multimedia Act, that has been there since 1998, went from about 10 cases to 30 cases, and now it's reported by the government to be 186 cases of social media abuses in a year. So we see the trend where you defeat one law, another law comes in Malaysia. And we don't really discriminate how we use it, so we tend to use any law, cross-cutting. Internet law can be used for against journalists. Like recently, our online media, Malaysia Kini, one of the biggest online media, they are used to be called alternative media, but based on readership, I think they are the mainstream news nowadays. Their executive director and their editor-in-chief was charged under Communication Multimedia Act for posting a video of a press conference of a former government politician who criticized the Prime Minister and made police report against the Prime Minister. So they were charged for that. We have artists, punk rock artists, that posted very interesting photo of the Prime Minister with a vampire face, charged in court. A satirical post of where he mimicked our government's. We have this multimedia commission thing. They kind of do all the internet censorship and things of that sort. They have this kind of standard template statement for porn sites and anything they block. You'll just say, this website is blocked. For more information, refer to this website. So the guy made a satire of that image, and he was charged in court. Now, those are still pretty standard in Malaysia, getting dragged to court and whatnot. But what is a bit worrying nowadays is, Sedition Act in the past was used to target politicians. The Internal Security Act was targeting politicians. But the Communication Multimedia Act in Malaysia is targeting the general population. People that it's impossible to identify because you have no idea who they are. It's just a Facebook post or a Twitter post. And in Malaysia, having your name on Facebook and Twitter is quite rare. You always have a very strange name. Case point example, there was this, at one point there was this football related arrests. Yes, related to football. We're not in the UK, but people get very angry about football anyway. So what happened was, one of our crown prince in Malaysia, I'm not going to point out who is it in case I get lynched back home. He is, no, lynched, not charged. He is kind of the manager of a football club in one of the states in Malaysia. Their team had a game with another team from another state, and they won the game. So he very graciously posted a photo of him feasting upon the other team's emblem, which was the elephant. So obviously, any football fan that sees that and they support the team, they'll take offense to it, and they start lashing out and say, you know, that this is not nice, and then you guys just won the game, doesn't make you guys the king of the world kind of thing. So next thing you know, you have 11 people that was arrested, detained for 13 days. And one of them was actually a fisherman that was somehow fishing off the coast of Malaysia, and somehow the police found him and grabbed him. And he doesn't even have a Facebook account. And the post was allegedly made on Facebook. So you had the odd head-scratching moment. Why was he arrested? Or better question is, how did they actually find him off the coast of Malaysia and arrest him? He was on a boat, for crying out loud. So there's this kind of thing that's going on that's a bit worrying, but it's hard to pinpoint exactly how. And there's another trend that linked to that is what I would describe as local extradition. So internet is everywhere in Malaysia. So you can be in northern Malaysia and you can post something, but somehow the arrest will not be done by the police there. It will be done by the police on the southern state, which is about 700 kilometers. Imagine from the southern border of Thailand to the border of Singapore, that's how far they'll bring you, literally. So we have had some activist friend that was arrested that way. He went on missing for about 12 hours when they bring him south. And halfway through, when he crossed over the border to the southern state, the police apparently pulled out their automatic weapons. And it obviously will freak you out because you're just in for something relatively minor, and someone suddenly just pull out the gun on you. And when he asked, what's the gun for? And they just look at him and told him in Malay, you know who's going to attack us. So it's like, what? But yeah, so that's Malaysia. So this kind of trend of local extradition has been going on left, right, center. And even our police headquarters have noticed that we tend to attribute a lot of these arrests on online posting to the southern state because they seem to have a cyber division there. So at one point, the police headquarters realized that they can abuse this thing. It'll divert pressure off the headquarters. So what they did was they sent their boys to arrest a former journalist that made a comment that supposedly insulted Islam somehow. It's not even close to Islam, but somehow it was insulting Islam anyway. So they sent someone to his house 5 a.m. in the morning to arrest him. But the moment they arrest him, rather than bring him to the headquarters, they sent him south. So everyone was like jumping on the guns and wondering, why is the southern police arresting him and whatnot? And then suddenly we found out from him that the police that arrested him wasn't from the south. It was from headquarters. And then they suddenly have a big, oh, I see what they've done there. And it's a trend that they've been continue practicing. So you have these cases of local extradition. You may be in Kuala Lumpur where you made a post where our what we call criminal procedure code dictates that you must have be trialed in the Kuala Lumpur district area in that sense. You're still arrested and brought to Johor and charged there. So it brings about another kind of extra burden on people. But so far, there's not a lot of prosecution or case that gone to trial. For most part, they either force people to plead guilty and get a small fine of maybe 2,000 ringgit, which is about $400, $500, yeah. And in cases where it's an activist and they challenge it, most of the time they have no evidence to push forward, so they kind of just drag on the case. I have a friend that has been detained, tortured for about 3 weeks, and his case has been on hold for the past year or so. So there's things like that going on. So yeah, that's the gist of it in brief. If there's any question, I can always answer it after this, I guess.
Thank you, Dobby. We're going to turn to Ed, and then we have one additional speaker as well. Bishaka, we want her to speak a little bit about, Bishaka and Smita, a little bit about the sexual expression side of things, because that's also one of the things that keeps coming under attack when we're talking about criminalization speech and how it's used as an excuse. So Ed, from a media and journalism sort of response, and then the sexual expression angle.
Thank you, Malavika. Thank you also to Dobby and Patrick for making my job easier. Now you know what's happening on the ground in Malaysia and Cambodia. I'm afraid in the rest of the countries in Southeast Asia where our work is focused on, the picture is not that good. Just for context, for example, all 10 ASEAN member nations. You know the Reporters Without Borders annual ranking on press freedom, right? 182 countries, number 1 is the most free, number 182 is the least free. All Southeast Asian countries are in the bottom third. So it's that bad for the media in general. So within that context, you have many countries with a culture of legal repression on the media, to name them: Myanmar, Laos, Vietnam, Singapore, Malaysia, and now increasingly Thailand. There's a threat. So that kind of an environment where media is self-censoring. Yeah. And now, from our observation, the governments in the region are trying to shift that culture of censorship and self-censorship to online expression. The problem here is that you're not just talking about media, you're talking about citizens, about the capability of ordinary people to express themselves against political or other views. So there's that increasing repression. So in the region, more or less in 2012, except for Cambodia, every region now has a cybercrime law. Every country in the region now has a cybercrime law. Yeah. So and many of the restrictions that are criminal in nature most of them have put these restrictions online. Even the supposedly free Philippines, where there's a constitutional provision that you cannot have a legal restriction on freedom of expression, freedom of the press. Okay, so what's the impact on the media? So as I said, moving the culture of self-censorship and censorship, the governments want to do this now to the people who are now suddenly having this unprecedented ability to express their views publicly. Yeah. For example, I'll just name one more country where the situation is quite bad: Myanmar, which has transitioned from 50-year military regime to a semi-military regime, now to a supposedly democratically led government. Specifically, I want to focus on Article 66D of the Telecommunications Law, which has a number of prohibitions about what you can do online. So presently, there are about more than 80 persons who are being charged under this Article 66D. And these are like minor crimes relatively, although criminal. It's not about, the penalty is 5 years, but the law says violations are unbailable. So once you are charged with this, you are detained. And among these 80 or so fellows charged, there are about 10 journalists charged under the telecommunications law. The problem here is that in Myanmar, Facebook is the internet, yeah? And most journalists, most newspapers have online accounts, and if they share the news there, that's easily, and if you offend someone, you can easily be charged with a cybercrime law. So it's that bad. No? So you have this new law. Supposedly, the Myanmar press legal environment has become freer, but then they have these like booby traps of laws that they can easily ensnare journalists. Yeah. So the final point I want to make is that, as probably alluded to by Patrick and Dobby, that the importance of the political context of how all this is happening. Yeah? The criminalization of free speech depends on the political regime. Patrick said about how the Prime Minister of Cambodia, like for example, 2 weeks ago he said he threatened that there's a threat of civil war in Cambodia. Yeah? So that kind of speech has led the police to crack down people who are posting in support of the opposition, to monitor monitor the Facebook users. So there's no law, but then they can, the political pronouncements of political leaders have made the job of the police easier, and the ruling party easier to crack down. Yeah, and it has also resulted in a double standard of law application. It's basically against the enemies of the regime. Like for example, in the Philippines, where I come from, we have a cybercrime law where supposedly penal code provisions are punishable, right? But the administration has launched a campaign of hate and violence and threats, including identity theft in many cases. And that's technically legal, but they're using it. And but no one is being charged. So double standards. Okay, so that's it. Thank you.
Thank you, Ed. I think it's so important that the point that Ed made, which reminds us that net neutrality is not over, and it's something that's still very, very relevant to all of the issues that we're discussing, even in this space where people think Facebook is the internet, and also to sort of focus on the role of platforms and providers, where on one hand they're enabling expression and providing a mouthpiece and amplifying content and enabling assembly, but on the other hand, we really have to think about the power that platforms have and the amount of data that they can collect and share with governments, and sort of that dual nature of platforms in this space, and the extent to which they actually, work with governments and repressive regimes. So I'm just going to turn to Vishaka and Smita from Point of View, and then we're going to open it up to questions. I think there's so much to unpack here, and we'd love to hear from all of you.
Super, thank you. Okay, we'll try and be brief because we know there's a lot of questions waiting in the audience. So both Smita and I are from India, and I want to start by saying that in the last 2 years, we've seen unprecedented levels of censorship in India, both online and offline. So for instance, if we look at films, we see that a number of words which we would not ordinarily consider sort of censorable, including gay, lesbian, intercourse, etc., have been struck down by the censor board. And this is something that we see as as censorship of legitimate sexual expression, these kinds of words. Similarly, if we move into the digital domain, we see very much a similar trend continuing, and I just want to start by saying 3 sort of framing things. One is, I think it's very important for us to, when we talk about sexual expression, to think of it as a valid and legitimate form of expression, a political form of expression, like more conventional and political and religious speech. Not to think of it as the illegitimate sibling of free expression, right? It's as valid as any other, particularly when it's consensual. The second thing that I want to talk about is actually Shohini Ghosh, who's done a lot of work on offline censorship, uses a very interesting frame of imagined harms and actual harms. And when we think about obscenity, the question is, or obscenity laws in India, which is what we are going to talk about, how those have been used not just to stifle sexual expression, but also to stifle other forms of expression and criminalize them. I think it's useful to think about, is obscenity to begin with as an offense an actual harm, or is it an imagined harm? And by imagined harm, what I mean is, obscenity is something that we think of as a public harm, a moral harm, and I would say also a preemptive harm, because often publications and content is pulled down before it can actually harm. So it's somewhat futuristic, actually. In contrast, if we look at the framing of actual harms, these are often private. These have already occurred in the past and need redress. And there is no doubt whatsoever that this is a harm that can be converted. It's not a speculative sort of situation. That said, there are 3 laws, 3 sections of the Information Technology Act in India, which we've been studying for a while. One is Section 67, which directly regulates obscenity through the use of 4 words: lascivious, prurient, depraved, and corrupt, which again somebody was talking about colonial era legislation. It's the same right here. We also have Section 66E, which prohibits the capture or transmission of images of private parts without consent, and which is most directly related to sort of privacy as a right, or looking at consent being violated without, even though we don't have a constitutional right to privacy as of yet. And the third one, which is very interesting, is Section 67A, which actually regulates sexually explicit practices or acts. And I think the question there again is that when we already have obscenity legislation, is there a real need for something that also prohibits that which is sexually explicit? Or are we sort of thinking that naked bodies are inherently harmful when we think of legislation of this kind, right? So going forward, I will hand over to Smita, just so that we can demonstrate both how this is used to stifle, say, the kind of speech. One example, which is you can have a situation where you have, say, 2 consenting adults, whether they are a man and a woman and a woman, whatever. Let's say they exchange intimate images with each other, right? This can often, even though it's consensual, this exchange and production of images can often get criminalized as under Section 67 because it's treated as obscenity. So that is a huge problem, but even more disturbingly.
Hi. So as a part of the research, we looked at media reports of 99 cases and analyzed it like as a part of the research. And there were some about 6 to 7 trends which emerged from the analysis. One of the biggest things was, and this was, just to clarify, these were media reports from 2015, 16 and 2017 as of now. And there were some trends which emerged and it just got progressively stronger. One of the main things which came out was the fact that Section 67, which is aimed at controlling obscenity, is being used more and more as a tool for political and religious censorship. A very, very recent example is that of the Prime Minister of India, Modi. His photo, someone added a Snapchat filter of dog ears to his photo, and they, it's a comedic group, it's a comedy group in India, and they put it up on Twitter, and they were immediately charged under Section 67. Now, is the dog obscene? Is Modi's face obscene? Like, you never know, you don't know what they're aiming at here. And another example of this is, we live in a state called Maharashtra, and the Chief Minister is Devendra Fadnavis, and he had put up a photo on Twitter where he and his family are on a yacht. Just to clarify, they're fully clothed and they're just lying about there. And someone tweeted the photo out saying that, you know what, there's a drought in the state and the Chief Minister is lolling about on a yacht. He was immediately charged under Section 67. Again, what is obscene here, no one knows. And it's not
the cost of the yacht.
Probably, yes. Another one more trend in with the usage of 67 is how a lot of people are using it to address online harassment. The thing is, as Nandara mentioned, Section 66A, which used to be earlier present in India, was used for addressing cyberbullying and online harassment. In its absence, because 67 is being treated as a dump for everything, it's also being used to treat online harassment, which is, I'm guessing, is a good thing compared to all the others, but it's still a disturbing trend because then you are only addressing the obscene bits of online harassment. What about those which are not obscene? Like, you're only focusing on the sexually explicit messages. You're focusing on the rape threat, but you're not addressing the other harms which come with online harassment. What Bishaka was telling about how consent is ignored in laws like Section 67. A very interesting case which came out during our analysis. It involved a man and a woman who were in an extramarital affair. They planned to attack the woman's married family, like the family she was married into, and they planned the thing, and they assaulted her mother-in-law and husband and all of that. And when the police filed the cases, they filed the charges of murder, assault, etc. They also charged them under Section 67 because they found messages on both their phones of like them exchanging images. Now, how that is relevant to the murder, I have no idea. But because it existed, they ignored the fact that they exchanged it consensually and just filed them under Section 67 anyway. And I think this is a very, very dangerous precedent to set in any country, like to use one obscenity, which is not defined, and to use it for censorship in these forms. So yeah, that's all.
Thank you so much. We'll just take a couple of really quick questions because we're running out of time. So Al? Anyone else? Yeah, okay. And okay, so we'll take these 3 questions, one in a row. Can you make it really quick so we can also get responses? Do you want it as well?
Seeing anything of this type in your research? First is real name policies as a deterrent to expression. Second is I don't know, you referred to earlier as a heckler's veto. I'm referring to, yeah, mobs, digital mobs, trolls, etc. Whatever, computational propagandists, etc. Whether they're humans or bots, and the chilling effect that they create, and the auxiliary problems of takedowns that result from these social media wars. And the third is also, I'll pick up from Malavika's net neutrality comment of role of platforms and providers. Are you seeing in your countries that they are cooperating, complicit, for example, in takedowns, or are they fighting back the way I was just reading an article about, yeah, Apple refusing to give the FBI personal information. So what's the situation of the relationship between the third-party intermediaries and the instances where the state is demanding their complicity? Thank you.
Thank you. This gentleman here. Just so it can be on the transcript.
Thanks.
Yep.
Yeah, I was just a little curious. We heard about India, Pakistan, Philippines, Malaysia, Cambodia. Any representative from Thailand? We'd like to know the case of Thailand. Okay? Is there anybody who can say a few words on Thailand?
We do the research, but yeah.
Yeah.
Okay.
Thanks.
We'll just take the final question here and get a couple of quick responses.
This is really for Ed Legaspi of SIPA. So I think there's really the common thread among these cybercrime laws is that first there's really strict intermediary liability, like even mere liking, sharing, or tagging, which is very relevant in the context of Thailand, Chiranuch case. So what do you think is the most effective way to deal with very strict intermediary liability? Second question is, there's also a common thread in this cybercrime laws in that false information that threatens national security is criminal. And there's also the rise of fake news, which sometimes is even promoted by governments. So how can we effectively address fake news vis-a-vis the cybercrime laws and freedom of expression? Thank you.
Great. Thank you. Nika?
I shared this with Gaia yesterday, but just recommendation of how to move forward with the research is actually thinking about the source of funds, no? Of why, because usually when you have a trend of, you know, legislating these laws, you also see the why this is happening. And actually, in the case of the Philippines and in other countries in Asia, we've seen EU funding initiatives like these. Like, there are projects like the GLACY of, I think EU or the Council of Europe. I shared it on my Twitter. It actually is funding or increasing the capacity of you know, the judicial system or judiciary to be able to address address violations online. So sometimes when they want in the process of, you know, addressing these violations online, they legislate cybercrime laws that are also repressive. So
we have 3 minutes in which to end.
There's some question from remote participation. Is the Cambodian law that penalizes political parties for support shown by convicts violating any constitutional protection? If so, has it been challenged yet?
Great. Go ahead quickly.
So just to make a comment about Sri Lanka, in the recent news, there was a mention by the government that they hope to restrict social media in a certain way. We're not sure as yet how that it's done. But the most recent elections is when we saw everyone taking up social media to express themselves. Politicians, women, men, everyone. I mean, we even saw female politicians from the grassroots who put up videos of themselves and commented on the situation. So in the Constitution, there is the Constitution guarantees freedom of expression, but this does not apply to the internet, and there is no implication that it does. So now we're a little concerned as to how these restrictions that the government is hoping to impose on social media is going to take place. Thank you for sharing your comments. I was wondering if there is any ways in which that you all are trying to counter these measures, and if you could tell us a bit about it.
Okay, great. We'll keep going over unless someone stops us. Oh, it is. Oh, yeah. Minor acts of subversion. Okay. Geeta, do you want to just answer sort of the questions about real name policies and heckler's veto and vigilante across, since you're doing the methodology?
There's one bit that I want to answer actually, which is that these sorts of situations is where the international standards become particularly relevant. In the LaRue framework, for instance, there are 8 issues that he looks at: arbitrary blocking of content, cyber attacks, criminalization of legitimate expression in situations like that, which are particularly relevant when we look at current issues in these countries. So that's actually the only thing that I wanted to share right now.
Ed, do you want to answer the question about Thailand and also the gentleman who asked you about the media?
Actually, Thailand is a good case study to answer all those questions about real name policy, intermediary liability, except fake news. We're still trying to wrap our heads around how to address that. Although there are a few issues that are already okay. Thailand. Thailand is a bit famous among internet advocacy circles about the case of Prachatai, who was charged in court for intermediary liability. They have failed, as in the case the editor was charged for not deleting an illegal comment fast enough. She deleted, but it's not fast enough. They said she should be, as an educated person, she should be responsible enough to see that when she saw it, deleted it immediately, but it stayed in their forum for 5 days, and then that wasn't fast enough. So in the end, Prachatai, she was convicted with a suspended sentence. The online comment section of this online newspaper has been deleted permanently. So that's how it happens. The good news is in Thailand, that law on intermediary liability has been softened a little. So there's appeal for, there's now room for appeal. So you can argue that however you want to argue, but it's not that harsh anymore. So that brings us to intermediaries like Facebook and Google. Now there's the trend, especially in Thailand, of these social media giants, which are quite alarming to follow national laws as a basis for censoring content. And if you're in a country with a good freedom of expression tradition, that's good. But this is Southeast Asia. You can go to jail for insulting a dog. Yeah. So that really, I think, is something that we must put forward to these internet giants. What do you do about this? Now, 5 years ago, their platforms are refuge, spaces where people who are censored in the mainstream media are able to express. Now that's not possible anymore. So I guess that's work that we need to do. And then real name policy. You see your tags, right? You have a unique identifier. That means you're, as users, you're registered in Thailand. Everyone is required to use. Actually, expats like me who live here, we are asked to share our Facebook accounts, all social media accounts. So that kind of actually very real surveillance and threats to your, that's pushing all people here in Thailand. So you should be careful on what websites you visit, right? Especially using this one. Okay, so that's Thailand, and the recent developments, especially this year, are quite disturbing from a freedom of expression perspective. Name it: broadcast media, print media, online media, social media. Everything is being restricted.
Talking about double standards, I really wish we could put governments, we could hold them accountable in this same thing. You haven't deleted the ridiculous laws you've had on the books for a long time, like you haven't deleted it fast enough in an alternate universe somewhere. Geeta wanted to make a quick point about intermediary liability, and then I'll ask Pat to answer the remote question we had about Cambodia.
I just wanted to offer a sort of interesting example from India. Prior to 2015, India had a situation where intermediaries practiced private censorship. That is, if individuals sent out complaints to the intermediary, they were required to respond within 36 hours. And in many cases, in order to avoid action from the government, the intermediaries would just take this information down, take the page down, or take the comment down, or situations like that. However, in a positive move, after 2015, there was a Supreme Court judgment, the same one that Nayantara was talking about, which struck down the draconian section 66A. Now there's a situation where intermediaries are only required to take down the content if either the government sends them a notice or if there's a judicial pronouncement. So now there's a situation where private censorship is limited in India through the intermediaries, and I feel like this is a positive move.
I just want to add that responding to the point whether intermediaries actually comply with orders, they do that sometimes. And one case where a judicial pronouncement was made was there's a preference of male children over female children. So a lot of people were found to be. So it was a case about sex determination kits, and the Supreme Court directed for all search engines to ban ads that sold sex determination kits. So how they did that was through keyword banning. So 43 keywords were banned on, or are banned on all search engines.
Just again a quick add. I think it's great that, as you said, private censorship has come down due to judicial sort of intervention. But on the other hand, private censorship is very much alive and kicking in terms of just their own standards, right? So we run a website on sexuality and disability, and we have women with disabilities actually blogging about their experiences of love, romance, marriage, etc. And we face huge problems on Facebook. It keeps getting taken off. We run another site on looking at the intersection of gender, sexuality, and technology. And again, for us, we're a small non-profit. For us to get readers, we have to use social media platforms. But again, it keeps getting taken off, so we're like every second day we are going back and forth trying to figure this out. So some forms of it are still alive and kicking.
Yeah, just to respond to the remote question. Yes, I barely touched upon the provisions in this recent amendment to the law on political parties, but there are many, and there are many ludicrous ones, including you can't use any image of an individual, any religious or national symbol in any posters, advertising, or public communications of the political party. And then obviously the banning of association with convicts of even the most minor crimes for life. And then the arbitrary power upon the Ministry of Interior to indefinitely suspend political parties based on their interpretation of the law with no recourse to judicial oversight, which can go on forever. They can decide to suspend a party for 99 years, for example, or 500 years. So yes, there are huge constitutional issues: freedom of association, expression, the right to participate in public affairs of the nation. We, among a coalition of civil society organizations, produced a legal analysis of the draft, along with a letter to, firstly, the Senate to ask them to reject the law. We submitted it, and they rejected it for administrative procedural reasons. We then sent it to all members of the Constitutional Council for their consideration. And again, they said, we as civil society have no legitimacy in the interpretation of constitutional norms. They also rejected it. And then we had drafted a letter to the King of Cambodia to request him not to sign the law to promulgate it. But the King, as he has done in respect of highly controversial legislation in the past, went for a medical checkup to China. So that's where he is now. And in those cases, the bill reverts to the President of the Senate, who is, a stalwart of the ruling party. So he is expected to sign it today or on Monday, and he has no veto power either. So yeah, we did our best. In the end, we had to release a joint statement press release along with the legal analysis and email it to all these actors. But officially, we were ignored despite trying to access every single channel. Before I give up, I just wanted to mention as well, Ed mentioned every country in Southeast Asia thus far except Cambodia has a cybercrime law. Not wanting to be outdone by their neighbors, Cambodia also has a draft cybercrime bill. We've seen 2 variations of it so far, actually quite different, but both unduly restrictive and not in compliance with international standards. And I wanted to touch on this because of the comment of international interventions and funding, because around the second draft of the cybercrime law in Cambodia, it was announced that technical assistance will be provided by the US Department of State, which we found, interesting, potentially a good thing. It should be a good thing. We would expect higher human rights standard and norms to go into the drafting process with the technical assistance of the US government. That being said, it's still been opaque. Despite their involvement, it has not been a transparent legislative process, and that has not been improved by their participation. So yeah, it's an interesting question you raise. Why are these major international powers involved, and what are the full motivations behind that? I think very relevant.
So Ed wanted to just make a quick follow-up point about Thailand, and then would any of you like to answer the question about Sri Lanka?
Okay, before you conclude that Thailand's intermediary liability law is much improved, the administrative instructions are actually under threat. No? And this is not like legislation we can lobby about, it's about content. No? The pressure actually for Facebook and YouTube to ban content began with the local intermediary liabilities. There was an order for them to, hey, what are you doing about this illegal content that's being done, no? Before they sort of resisted and then explain to the government, no? how this works. So the government then started to pressure Facebook and YouTube and submitting why this content should be illegal. Second is there's also the plan to restrict more control. Thailand has introduced the idea of one gateway for the whole country to to channel all internet traffic to a government-controlled channel. There's a very successful campaign against this. One of the, it's unprecedented in Thailand's online campaigns, 100 or 200,000 signatures against it. But it's still there. It might be happening. But the point is to have the illegal content coming from outside Thailand to prevent them from reaching the local shore. So yeah, there's a gain in this intermediary liability law, but elsewhere it's really much worse. There's also the new takedown clause of the digital economy ministry, which doesn't have to be justified by the court order.
On the point about Sri Lanka, I think that's exactly why this research project even exists, because of the fact that online and offline are treated so differently in a lot of regimes, and certain rights and protections don't apply, whether in the constitution or elsewhere. We're going to wrap up. I'm just going to ask everyone on the panel, and Sadaf as well, if you're still around, to give us your one solution. If you had a wish list, if you could be king of free expression for one day, what's the one solution you would love to see in your particular jurisdiction? Tweet length would be great. Thank you. We'll go with Sadaf first, if you're still there. Unmute if you are. Okay. She's not online? No. Okay. Okay. We'll go this way. Nayantara, do you want to kick it off?
Yeah, I guess an opportunity to engage with any draft law that comes out, because many times when there has been engagement, they have revoked it right back. So,
for all drafts of laws to be public.
An independent judiciary to monitor enforcement, consistent enforcement of those laws, rather than arbitrary interpretation.
We've just finished our research project for it.
I think cybercrime laws are clumsily worded because they provide ready weapons for incumbent political parties to crack down against their enemies.
I have no idea. Because if I want to say it's repealing a law, there's about a dozen laws that is repealing or amending. If I want to say change the government, the opposition is not going to be fully supportive of human rights principle in the first place. If I want to say a mass movement to change, that's going to take years, if not decades. So, no, not giving up, but just, yeah.
This is the new generation that's going to inherit this fight from us. Damn it. Okay. Thank you so much for sticking around through the break. You've been great. And thank you to all our wonderful panelists. Exactly.